I am Lois Beasley Carlisle, and we got cut off on the last tape, but that's okay. We were talking about whether you could add post-petition rent or pre-petition rent into a bankruptcy. Now, pre-petition rent, if you don't owe the rent in full by the next month, then yeah, sure, you can spread it out and do a payment plan to catch up on your rent. If you do have like several $1,000s worth of rent coming due next month, it may be better just to move off, leave the place, and get another place, and put all the pre-petition rent into bankruptcy. You have to keep post-petition rent and mortgage payments paid after you file the bankruptcy. The creditor can file a motion for relief from stay if they don't, to throw you out of your house. Now, you can include mortgage arrearage that you're behind on as of the date that you file the bankruptcy. If you whatever month you file the bankruptcy in, generally you're going to start paying your mortgage payment the next month. The trustee is going to charge 6-7% or whatever the going rate is in your particular city of each payment to handle the processing of your case and paying all your payments to all your creditors. When are your debtor court payments due? They are due within 30 days of filing your case. If you file your case on the 15th, the money for your payment should be to the trustee, where it clears the bank by the 15th of the next month. If you're going to write a check, that means you need to pay your bankruptcy at the first of the month to give the check time to clear, because the trustee is going to hold those checks at least 14 days before they pay your creditors. If you're paying cash, it'll take 3 days to post, something like that. Nobody is going to remind you to pay your payment every month. You have to be responsible and just do it. Mark it on the calendar. Know that you've got to pay it when you get your paycheck. Now, how can you pay it? You can pay it weekly, bi-weekly, bi-monthly, monthly. Doesn't matter. You can pay it any way that you want to pay it, as long as you have the full amount paid every month. Now, you have to put your case number, your full case number, on your check or money order when you send your check in, plus your name if somebody's paying it for you, so the trustee knows whose account to apply it to. The first 2 numbers in your case number are going to be the year the case was filed. The rest of the numbers are going to be the number of bankruptcy that was filed in. You can pay by payroll deduction. You just have to let your attorney know to get that set up for you. Each creditor is going to file something called a proof of claim. You need to make it a point every month or 2 to get a printout from the court, and the attorney can show you how to download it and check and look and see if those claims look accurate. By the claims bar date, which will be printed on your paperwork that you get from the court in the mail, you need to look at all your claims yourself and make sure they look like money you actually owe. If you don't object, the attorney's not going to know it's not your debt, because you get mailed a statement from the court. You're just going to pay bills that maybe aren't yours. For example, I had one client, this has been several years ago, but he paid Credit Acceptance. They're a big company. He paid them, I don't know, $10,000, $12,000, $15,000. And he called them near the close of his case to find out when he could get his title, because the car was paid off. Well, they had filed a claim for the same man by that name, but it was a different car. It wasn't his car. And so we then had to file an AP to have that situation fixed, because his bankruptcy was about ready to pay out. And here he'd been all these years paying on the wrong man's car. And his car didn't have a payment paid on it. And so we had to, but, Credit Acceptance was the right creditor, and they had filed a claim, but it's just the 2 men had the same names, and it was a similar make and model of car. That doesn't happen very often, but that's why you need to look at your paperwork and make sure you're paying your own bills and not somebody else's. There's a claims bar date. After the claims bar date, then creditors should have all their claims filed for by then. There are different kind of notices that attorneys are required to give you. One is a notice required by Section 527A1, And Section 527 requires the debt relief agency, which is what we are, to provide the notice required by Section 342B. That notice requires before the commencement of a case under this title by an individual whose debts are primarily consumer debts, the clerk shall give notice, individual written notice containing a brief description of the chapters 7, 11, 12, and 13 and the general purpose, benefits, and cost of proceeding under each of these chapters and the types of services available from credit counseling agencies, and statements specifying that a person who knowingly and fraudulently conceals assets or makes a false oath or a statement under penalty of perjury in connection with the case shall be subject to a fine, imprisonment, or both, and all information supplied by a debtor in connection with a case is subject to examination by the Attorney General. The notice required by 527A2, to the extent that the Section 342B notice does not provide certain information within 3 days of when a debt relief agency first offers to provide bankruptcy assistance, it must provide the assisted person with a notice that all information the assisted person is required to provide with a petition and during a case is required to be complete, accurate, and truthful. All assets and liabilities are required to be completely and accurately disclosed, and the replacement value of each asset, as defined in Section 506, must be stated in those documents where requested after reasonable inquiry to establish such value. Current monthly income, the amount specified in Section 707B2, and in a case under Chapter 13 of this title, disposable income determined in accordance with Section 707B2, are required to be stated after reasonable inquiry. Information provided may be audited, and the failure to provide such information may result in dismissal of the case or other sanctions, including criminal sanctions. Additional information required to be provided under Section 527B is if you decide to seek bankruptcy relief, you can represent yourself, you can hire an attorney to represent you, or you can get some help in some localities from a bankruptcy preparer who is not an attorney. The law requires an attorney or bankruptcy petition preparer to give you a written contract specifying what the attorney will do for you and how much it will cost. Ask to see the contract before you hire anyone. The following information helps you understand what must be done in a routine bankruptcy case to help you evaluate how much service you need. Although bankruptcy can be complex, many cases are routine. Before filing a bankruptcy case, either you or your attorney should analyze your eligibility for different kinds of debt relief available under the Bankruptcy Code, and which form of relief is most likely to be beneficial for you. Be sure you understand the relief you can obtain and its limitations. To file a bankruptcy case, documents called a petition, a schedules, a statement of financial affairs, and in some cases a statement of intentions need to be prepared correctly and filed with the bankruptcy court. You will have to pay a filing fee with the bankruptcy court. Once your case starts, you will have to attend the first meeting of creditors, where you can be questioned by a court official called a trustee and some creditors. If you choose to file a Chapter 7 case, you'll be asked by the creditor to reaffirm a debt. You may want help deciding whether to do so. A creditor is not permitted to coerce you into reaffirming your debts. If you choose to file a 13 case in which you repay your creditors what you can afford over 3 to 5 years, you may also want help with preparing your Chapter 13 plan and with a confirmation hearing on your plan, which will appear before a bankruptcy judge. Okay? So that's a lot of technical stuff, but that's to explain to you the process. If you don't turn in all your tax returns, the tax assessed values of your property, and your pay stubs, your case can be dismissed. If you don't turn in all the questions that the bankruptcy court wants answered, your case can be dismissed. If you don't sign all the documents the court requires, your case can be dismissed. You need to dress like you're going to church unless you're coming from work. Don't, of course, wear a hat in court. Bring a picture ID and social security card with you to court just in case that court requires one. Don't have your cell phone turned on in the courtroom. You risk being kicked out of court or having your cell phone confiscated. Now, attorney's advice and the kind of help they can give you in a bankruptcy is going to be based on what you give the attorney. If you don't give the attorney all the information and all the documents, your bankruptcy may be faulty in one way or the other, and some creditor down the road may file a lawsuit against you and scream fraud and say, he told us he had a riding lawnmower we could have a lien on. They didn't list a riding lawnmower in the bankruptcy. Well, Maybe you sold it, maybe you shouldn't have, because if you gave the creditor a lien on the riding lawnmower, then maybe you have converted their property that they have a lien on, but maybe it broke down and you threw it out. Just basically tell your attorney about all your assets, bank accounts with your name on it, even if it's somebody else's bank account, even if it's a trust account, and tell the attorney about all your debts. Disclose any and all accounts that have your name on them, even if you don't keep money in that account. Don't assume that your social media accounts are private or not relevant. The social media accounts, you could post some stuff on it that makes a difference. If you're filing a Chapter 7 bankruptcy and your social media account has pictures of all kinds of assets that you don't disclose, you could get yourself in trouble. What is raw land, family land? Debtors seem more than anything else to forget to list land that debtor has a financial interest in, but their brother pays the taxes, and they told the brother he could care for the land, live on it, so he didn't think I needed to list it. Another problem is omitting friends, family, the IRS. Of course, now we're required to list the IRS in the state of Alabama as a creditor, so you're going to catch them if you owe taxes. If you think you owe somebody, you list them. If you owe John, Sue, brother, sister, mom, dad, list them. This keeps John, Sue, brother, mom, dad, whoever from trying to force you to pay while you're repairing your financial situation. And they might accidentally get a payment from the bankruptcy trustee, so it could be a good thing for them. Off the top of my head, that's all I can think of right now. This is Lois Basley Carlisle. Take care.